Good evening, Joyiyoti. I'm Khushbu from Fox Mandal, and good evening. Hi, good evening, Mr. Ramakrishnan Viraraghavan. We are we are pleased to have you. Thank you for your time, and I am pleased to introduce our corporate partner, Mr. Arindam Sarkar,
Hi.
who is going to lead the deliberations for the evening with you guys. Thank you.
Thank you.
Thank you.
Hi, good evening, everyone. Am I audible? Okay. Welcome to Fox Mandal's fourth continuing legal education session. And as a firm, we've always, made the effort to promote legal education, particularly amongst the legal fraternity. And this is fourth of our many such efforts. And today's topic is online gaming laws in India. And I couldn't have asked two better, stalwarts of the industry to, to take us through this session. So I would love to, we are privileged to have amongst us two stalwarts from this industry, Senior Advocate and Barrister Mr. Ramakrishnan Viraraghavan, and of course, my friend, batchmate, and ex-colleague, Mr. Joyiyoti Misra, Group General Counsel of Gameskraft. Viraraghavan, sir, you would first give us an overview of the GST regime in India and how it would impact the gaming industry, how it has impacted and would impact in the long run as well. And then we look forward to Joy. Sorry, I'm taking the liberty of calling you Joy. So Joy will provide us with, an insight on the evolution of the regulatory framework of online gaming laws and the various issues that are being debated as far as the gaming industry is concerned. And of course, throw some highlight on his experience as well as his views on a very recent judgment, a landmark judgment which has been given by the Karnataka High Court in favor of Gameskraft. So with that, I would like to first introduce our first speaker, Senior Advocate and Barrister Mr. Ramakrishnan Viraraghavan. Sir is a luminary in the legal realm, possesses a distinguished career of spanning 37 years. He's a dual qualified lawyer. He commands expertise both as a Supreme Court litigator as well as a barrister in the United Kingdom. His legal acumen extends to international commercial arbitrations, where he serves as an esteemed arbitrator, recognized for his exceptional contributions to insolvency and bankruptcy laws. Sir has left an indelible mark on the legal landscape with precedent-setting cases. His profound understanding of tax litigation, constitutional law, criminal as well as civil matters underscores his formidable reputation. Moreover, Mr. Viraraghavan's scholarly pursuits are evident from his published books, The Law of Goods and Service Tax, a testament to his erudition and dedication to legal scholarship. As a revered resource person at the National Judicial Academy, Mr. Viraraghavan shares his expertise with fellow practitioners and judiciary members alike. Welcome, sir. It's a privilege to have you. And sir would first make a presentation, if I'm not wrong. And I would request all those who are participating in this session to let sir finish his presentation first. And then if you have questions, please note them down. You may either put them in the chat box or raise your hands. Over to you, sir.
Thank you, General Sarkar, and thanks everybody for joining in on this Friday afternoon. Now, let me start with the session on GST. Now, GST is a hugely
Can I mail you the link?
Beg your pardon? Yeah, GST is a hugely complex legislation, and in GST, I think the challenge is in getting simplicity from the complexity. I'm quoting Oliver Wendell Holmes, Senior, who says, "For simplicity on this side of complexity, I will give you a fig. But for simplicity on the other side of complexity, for that, I will give you anything that I have. Now, simplicity from GST, I will address in three triangles. Now, the first triangle is the trinity of supplier, recipient, and the supply. This is the first triangle of GST. Building on this first triangle is a second triangle, a hexagram, which talks of time of supply, place of supply, and valuation. And superimposing all on this, a nonogram, a third triangle, is rate, exemption, and classification. In these three triangles, you'll have about 60–70% of GST taken care of. Now we come to actionable claims and online gaming. Where does taxation of online gaming come in? GST has a particular schedule. It had a schedule 3 earlier, which talked of supplies which are not supplies of goods or services. So basically, these supplies were not taxable at all. And the entry there talked of actionable claims other than lottery, betting, and gambling, which means any actionable claim is not taxable unless it is lottery, betting, and gambling. Now, online gaming, according to the revenue authorities, fell within gambling. And the debate was, is online gaming or gambling? Basically, is it a game of skill? Is it a game of chance? Now, if it is essentially a game of skill and there is an element of chance, then it's not gambling. But if it's basically chance and there is a small amount of skill involved, it cannot be gaming. It must be gambling. Now, this was a huge debate, and this is a debate with Mr. Joyiyoti Misra's company won at the Karnataka High Court. Decisive judgment saying online gaming is a game of skill. It is not a game of chance. It's not gambling. The Supreme Court is yet to decide that. Now, to get over this, the revenue went backwards and they amended the GST Act in 2023. Now, after this amendment, the entry in the schedule was replaced and it now reads actionable claims other than specified actionable claims. So the assumption was betting, lottery, betting, and gambling were actionable claims, and these were defined as specified actionable claims. So specified actionable claims are actionable claims involved in betting, casinos, gambling, horse racing, lottery, or online money gaming. Okay. Now there's a distinction between online gaming and online money gaming. If there's an online gaming without any money involved, then, 1 second, I think I lost the screen. There is some difficulty here. Somebody has taken the screen out of my hands. Is that a problem there?
No, sir. So we have just opened the PPT. So
Oh, you have opened the PPT? Okay.
yeah.
Then
So
would you please go on to that slide where I'm talking about the 2023 amendment? It's probably the 6th or 7th slide.
okay.
Yeah, this is the one.
Yeah.
Okay.
Sandeep,
So
you can do
what
the full screen.
Please hold on to this. Now, what the 2023 Act said was all specified actionable claims were taxable. And specified actionable claims are claims involving betting, casinos, gambling, horse racing, lottery, or online money gaming. Now, online money gaming means online gaming where money is involved. If it's online gaming, where money is not involved, it's not taxable. The next slide, please. Next slide, would you please share the next slide? Yeah. This leads to a couple of problems. Now, you go to the first triangle, you saw the first triangle had three things: supplier, supply, and recipient. Now, if you go back to the last slide you just saw, how do you identify what is a supply in online gaming? Now, online gaming has two components. The company hosts the platform. It's like a table. Let's talk of a physical world. It's like a table on which four friends sit and play something. The table is hosted by the online company, and the game is played by the participants. So, and the participants pay a fee for the entry into that table, entry into that online platform, and then they bet, they have a prize money amongst themselves. Each of them contributes something from their pocket, keep it on the pot in the table. And whoever wins that game takes that pot back home. What is the supply here? From the gaming company's point of view, the gaming company supplies the platform, supplies the equipment, and supplies the game with the rules. That supply is a supply of foundation for the game, and that comes at a cost. Obviously, that's supply, and that has to be taxed. Now, take these 4 or 5 players who play the game. Could I have that screen, please? Yeah. 4 or 5 players who play the game. These players are playing among themselves. They are not supplying a game to each of them. Now, let's take another example. This is the game of mutuality. Now, I think that screen is going hugely elsewhere. Can we stick to the last screen, please? Yes. Let's hold on to the screen until I tell you to move. That's okay? Fine. The doctrine of mutuality is an exemption against supply. As you saw in the first triangle, there are 3 components. There should be a supply, a supplier, and a recipient. Now, let's say you go home, you cut something in a pot, you bake something, you bake a cake, and you eat it. Now, there is somebody supplying a cake, but who is it? You are cooking a cake for yourself. There is no supplier, there is no recipient, so that cannot be a taxable supply at all. This is the doctrine of mutuality. It's similar to a person who cannot make an income dealing with himself. There's no income tax there. Here, there's no supplier, there is no recipient. I make my own supply and I consume the own supply. There is no supply which is taxable under the GST. Now, the reason I'm saying this is because the Constitution of India gives the right to levy tax. And the Constitution gives both the states and the center the power to levy GST. Constitution of India, Article 366, has defined goods and services tax. It has not defined supply. I'm reading the definition of goods. It says goods includes all materials, commodities, and articles. It says goods and services tax means the tax on supply of goods or services or both, excepting supply on alcoholic liquor for human consumption. And then services have been defined as anything other than goods. So if you take goods and services tax, goods and services tax part has been defined, goods part has been defined, supply part has not been defined. If something has not been defined, you take the normal meaning of it. Normal, common sense meaning of supply is you're giving something to somebody. It needs a person supplying it, a recipient. And without these two, you can't have a supply. So let's get back to mutuality. Instead of one person cooking or baking a cake for himself, about 4 friends join together. They make the cake together and they eat the cake together. Again, you can't say who's the supplier and who is the recipient. This is called the doctrine of mutuality, where the supplier supplies to himself. It's mutual between the supplier and the recipient. They're all the same person. Now, if you apply this doctrine of mutuality to online gaming, you find the players are playing among themselves. They are betting, I can't even say betting, they are using prize money among themselves. They are identifying a winner among themselves and the winner takes away the prize money. Now, the gaming company, by its own contract, has nothing to do with ownership of the prize money. Could we go to the next slide, please? When the gaming company has nothing to do with the prize money, then the supply cannot be valued as including the prize money because there is no supply of the prize money. Prize money is the kitty which all the participants put the money in and they share it among themselves. The contract typically with the gaming company must ensure that the gaming company does not have any ownership. So if some civil suit is filed and properties of the gaming company are attached, this cannot be attached. The prize money is actually a property of the participants. The consideration for the participant, for every supply, you saw at the second triangle, there is a valuation. The valuation is typically the consideration for the supply of services. Here, the consideration is the entry fee for participation in online gaming. The prize money is never the consideration because the prize money varies depending on the participant. And the online gaming company doesn't have access to the prize money. Access as ownership. It holds it in trust aspect. So there is a difference between lotteries and online gaming, which the GST Council has wrongly equated. The Supreme Court has held that in online game, not in online game, sorry, in lotteries, there is a fee. The lottery ticket is a fee for participation and it is the price. So if you buy a lottery ticket for 100 rupees, hoping to get 1 crore of rupees as a prize money, the 100 rupees that you pay is both participation and it is the prize money itself. So the Supreme Court has said the entirety can be taxed. That is not so with online gaming. Typical differences are, let's say in an online gaming, the prize money is not guaranteed. In online gaming, the participants have a clear distinction between so much is a fee for participation and so much is the prize money contribution. In a lottery, the prize money is guaranteed. Even if only 2 people buy that lottery, the winner will get the entire prize money. And in a lottery, the prize money is contributed by the lottery organizer. And he has ownership of the prize money until it is given. So these are the essential differences between online gaming and lotteries. In valuation of the supply, the doctrine of mutuality will not apply to a lottery. And therefore, the GST Council equating lotteries with online gaming will not pass muster of constitutionality. Next slide. This amendment is not retrospective. The amendment is completely prospective, and even when it's prospective, the rules relating to valuation go far beyond the Act, because the Act talks of valuation of supply, and the valuation of a supply depends basically on the contract between the supplier and the recipient. If the supplier and the recipient agree that this is going to be the scope of a supply, the government cannot come over and say, look, I'm deeming this and that and something else as deemed supplies. That cannot be done because that goes against the constitution, which overrides the GST Act. So to summarize, these are the challenges in taxation of online gaming. Number one, doctrine of mutuality. Number two, the very definition of supply. Number three, is it gaming or is it gambling? And even assuming everything is now taxable, what is the valuation? And lastly, of course, retrospectivity. So this would be the challenges, but there are other challenges as well. Now, you talk of actionable claim. Let's assume that there is actual gambling. If it's gambling under the Contract Act, a gambler cannot sue for the winning. It's betting and gambling. It's a contract which is not legally enforceable. Now, if it is not legally enforceable, it cannot be an actionable claim because actionable claim by definition is a claim which can be enforced by an action in law. So with that, I close on the challenges of taxation of online gaming and over to Mr. Joyiyoti Misra, who will tell you the greater challenges and the larger context in which this industry is enforced. Thank you.
Thank you, sir.
I can take questions now or even later, whichever you feel is better.
I think we'll take the questions in the end.
Excellent.
Before that, I would like to introduce Joy to our attendees. Joy is presently the Group General Counsel for Gameskraft, one of India's homegrown bootstrap gaming unicorns. Prior to joining Gameskraft, he served as Uber's head of legal for the South Asia region. Before shifting in-house, Joy was a partner at one of India's leading law firms, Katan & Company, focusing his practice on M&A and private equity transactions. He's played an instrumental role in advising on wide-ranging policies and regulatory issues. He's worked on marquee M&A transactions across diverse sectors, as well as on complex and high-stake litigations on issues ranging from regulatory, competition law, and employment to tax controversies. Welcome, Joy. You're on mute.
Yeah, thank you so much. Thanks a lot for that introduction, and it's a pleasure to meet you, sir. Obviously, it was very edifying to hear you speak about the controversy that is ongoing. What I'll try and do for attendees is kind of initially lay out a little bit of how does all these controversies start. I'll step away from tax for a moment, and before I come to tax, one kind of disclaimer is that I'll not go too much in detail in tax simply because it's sub judice today. So while we'll touch upon the issues that has already been decided, I would rather not talk beyond a particular point, given that we are involved in an active litigation right now on that. Now, just on the concept of, and Sir touched upon it briefly, gaming and gambling. Now, that essentially is the crux of the debate that keeps on happening, whether it is in the regulatory arena or in the tax arena. Now, if we go back to our constitution, we will find that in list 2, that is the state list, there is an entry 34. Now, entry 34 provides states the ability to regulate betting and gambling, or to come out with legislations in relating to betting and gambling. So question that has always arisen is, does that extend to the states regulating online gaming, even if the games involved are not in nature of gambling, but are games of skill? What the states have typically tried to argue is that it does not matter as to whether the game itself is a game of skill or not. If money is involved and therefore you're paying for money, then it automatically translates into gambling. Now, this particular position has been thoroughly rejected by effectively all the high courts before which these issues have been challenged. So what you've typically seen, if you look back at the history of how this comes about, it comes about now for more than 100 years of jurisprudence. So the issues arose even during British India. It arose in England itself. I think we have a few participants unmuted. Yeah. All right. And if you look at our Public Gambling Act, effectively, you'd always find that there is an exemption given for games of mere skill. So question always arose was, what is a game of mere skill? And jurisprudence has shifted. Initially, there were some amount of jurisprudence which talked about as long as there is a modicum of skill involved, it should be okay and you can play with money. It's not going to be prescribed. It tilted fully towards saying that game of mere skill will mean that the game has to be fully of skill and no elements of chance. Now that got effectively authoritatively settled later and got followed even by a Supreme Court, where the test evolved was of preponderance of skill. So essentially, if there is a game which preponderantly is a game of skill, then the law is clear that it will be taken as a game of skill and will not come under the prohibition of any of the gambling legislations, including the Public Gambling Act. So therefore, whenever a state has tried to ban online gaming, and those legislations have been wide enough in their amplitude to take into account games which are even of games of skill, you've had high courts coming and striking them down. The most recent one was, in Tamil Nadu, where, Tamil Nadu initially had banned all games, including games of skill. That was challenged and was struck down. They changed the law. They again banned effectively everything. They included a schedule which essentially said that rummy and poker are hereby deemed to be games, gambling, and therefore, is prohibited even in the online space. The court read down that provision and essentially said that rummy has already been held by the Supreme Court to be a game of skill. Poker itself also is a game of skill, and therefore such laws cannot, operate on games of skill. Now, that decision itself has also been now challenged by the government of Tamil Nadu in front of Supreme Court. So today, the Supreme Court essentially faces or is seized with appeals that have arisen, number one, from all the regulatory challenges. So the recent strike downs have been in Karnataka, have been in Kerala, and twice in Tamil Nadu. All laws that banned online gaming, irrespective of skill and chance, were all struck down, all of which today are in appeal in front of the Supreme Court. If you look at 60 years of jurisprudence of the Supreme Court, it is fairly clear that games of skill are not only allowed, but the court has actually gone on to held that it is protected under Article 19. So essentially, a business that involves game of skill is a protected business. And to that extent, you cannot be, banning it. The law is very clear from other cases, as we all know, that you can regulate, something that is given under Article 19 to 19(6), but that regulation cannot go towards annihilation of that particular right. So that part is clear. We will see how the court decides on all of these matters. But that is where, from a regulatory aspect, this today stands. Now, let's go to the broader picture. What's happening in the broader picture? In the broader picture, actually, the industry was fairly happy when it had even people like our Prime Minister essentially realize the value that the gaming industry can have for India, the dreams of Make in India, and especially the role that it can play in making India a $5 trillion economy. Now, just to give you people, an idea of the size, if played to potential, gaming industry would be far larger than all other forms of entertainment put together. So whether it is music, movies, sports, everything put together is going to be smaller than gaming. That's the potential where the industry can grow to. Today, India's piece of pie of the entire gaming ecosystem in the world is less than 1%. It is dominated by the United States, followed by China. With the right kind of policies in place, India can probably get at least 5 to 10% share, which in itself is going to be massive addition as far as revenue generation itself is concerned. There are already 3 to 4 unicorns in this particular space in India, and there could easily be more if the right kind of policies are there. Now, coming back to this, so I think the industry was actually fairly happy and stoked to see that the Prime Minister himself has recognized the value. We saw some very positive movements coming from certain other arms of the government, which included the Ministry of Electronic Information Technology, when they amended the intermediary guidelines to come out and say that the gaming platforms and the gaming companies are also intermediaries, exactly like an Amazon or a Facebook, etc. And it talked about formation of self-regulatory bodies who would come out with, the rules in order to judge, which are kosher games and which are not. And the ones which are kosher, aka games of skill, will be allowed. And ones which do not pass that muster will not be allowed or will be treated as gambling, effectively. Now, while that law has been passed, the SRBs are yet to be notified. So in some ways, that law is in limbo. But be that as it may, that's one part of the story where we had one arm of the government very clearly taking a proactive step and a positive step in trying to come out with regulation. Now, one thing for the participants is, unlike many other tech-enabled sectors, the gaming sector has never said do not regulate. In fact, the sector itself has engaged actively with the government to say, please come out with a regulation, because what we do not want is to litigate in state after state, trying to overturn legislations which ban. We would rather have one central regulation, properly talking about regulation, put on, whichever, bells and whistles you need to put, we'll abide by it. So whether you want us to, abide by proper KYC mechanisms, PMLA related mechanisms, age gating, geofencing, all of that today is possible through technology. Industry is very happy to do all of that. And, let's go ahead and have that. So that's one side of the story. Even while we litigate in the GST sphere, we actually saw fairly positive movements coming from the tax side when it came to income tax. There was a lot of uncertainty as to how TDS rules would apply in online gaming. And in the last budget, we actually had introduction of new section to clarify how TDS is to be done. And the industry welcomed that. So to that extent, there were a lot of, tailwinds in some way to propel the industry forward. So therefore, what ails the industry today from a regulatory framework is that, number one, this debate of gaming versus gambling need to get settled once and for all. Probably it'll happen in the Supreme Court. And once that is done, hopefully in the state-related issues, it'll not be a problem. And then, of course, GST. Now, sir has, of course, talked about, the new law, and I'll not go there, 1st October 2023. It's still not under challenged. It is from, and enough has been written about it. I mean, this industry has essentially said that our fear is that while some of the larger players like us are probably going to be impacted, but we will survive, it's still roughly a 400% increase of tax outgo for us, which is massive. But what it'll might do, and it's not good for probably the startup ecosystem, is while the bigger boys will probably take the beating for a few years and survive, it'll, in all probability, annihilate the smaller players, because there is no way they can pass on this tax burden, because nobody's going to play if you're going to charge them that 28% GST on deposits. So that is going to be one. So you'll probably see a rise of oligopolies in India in the sector if this continues. And in some ways, that's not good from an economic perspective. What it could also do is the online gaming sector, if you participate as a player, you have to use banking channels to get in. So everything is out there in the open. Things can be looked at. You're using your bank or your credit card. There is no cash that is, sort of coming in. So there is no touch point with the parallel economy. But moment something gets exorbitantly taxed, chances are that you're going to push people into physical, kind of satta dens, essentially, and which are typically controlled by, unsavory elements in the society. So question that comes up from a legal policy perspective is that unwittingly, are we therefore making a policy which will, take or proliferate the black economy rather than giving fillip to the proper white economy? Number one. Number two, is there a national security issue, therefore, that automatically comes up? And as an industry participant, we have definitely requested even the MHA to look into it from that perspective, because those are definitely issues that need to get tackled. Number three, that happened immediately after we did our tax things, is it immediately gave fillip to offshore gambling, pure gambling online operators. See, the internet is boundaryless, right? You can jolly well write in a law that I will not allow this kind of sites to operate, but it's like a multi-headed hydra. You today ban something called abc.com, it changes its names into xyz.com and does exactly the same thing. So we actually saw advertisement come in the day after the 50th GST Council meeting from offshore gambling operators advertising to Indians saying no GST. No GST, play with us. These are, fly-by-night operators. These are pure gambling operators. So again, question is, unwittingly, have we played into their hands by doing this? And then that is definitely one of the points that the industry is raising for the new law. And we'll see where that goes. The Honorable Finance Minister has obviously promised a look back post 6 months. So we will be engaging with the government, hoping for a constructive dialogue, and see where that essentially goes. From that perspective, we'll see where that goes. Now, on the older law, where the entire tax controversy arose, which was in front of the Karnataka High Court and today is in appeal by the government in front of the Supreme Court. Essentially, what was the argument? And we'll only stick to that. The argument from the department's perspective was fewfold. They said, again, similar argument that has been taken in the regulatory matters. And it's the same argument they have now repeated in the Supreme Court. If you look at the SLP papers, you can always see that. Essentially saying that it is immaterial as to what the underlying game is. Whether it's a game of skill or not, if money is involved, it is gambling. In some way, they have taken the position, and as lawyers, they have taken the position that it is not something new. This has always been the law. 60 years of jurisprudence has not been understood by any of the high courts so far, and they have misinterpreted Supreme Court's decision. Heavy reliance has been placed on paragraph 12 of the Satyanarayana judgment, which held rummy to be a game of skill. Now, in paragraph 12, in the context of a penal gambling legislation, there is a side comment that their lordships make, essentially saying that if there were evidence led which showed that the house, or effectively the club in that particular case, made profit in some other way, then an offense may be brought home. That was the comment. Now, that has been interpreted by the department to say that the platforms charge money as platform fee, and therefore they fall within that prescription. What the platforms have always said is that we are intermediaries simply charging you a fee, essentially. We are not making any profit out of the game. The outcome of the game has got nothing to do with the platforms. In fact, we are not even concerned about it. Number one. Number two, you cannot interpret Satyanarayana in that particular manner, because Satyanarayana, then it will completely undo what Satyanarayana has actually said. You want us to remember that Satyanarayana said rummy is a game of skill, and on that basis, the club was exonerated from being a common gambling house. If this was the case, and even in that case, they charged a fee. The club charged a fee, essentially. So that could not have been, the interpretation. High courts have interpreted that last part of paragraph 12 to mean something like a side betting. So essentially, it means that if there are 4 people playing the game of rummy in a club, and somebody else, 2 other people who are not playing the game, have placed a bet on the outcome of that particular game, that may be gambling. And probably that is what is being referred to over there. So the Kerala High Court in the Jungli decision, when it struck down, Kerala's, regulation banning online skill gaming, has said so. The Karnataka High Court essentially also said so. Now, even in the GST matter, where a 21,000 crore demand was made by the department, effectively applying Rule 31A, which Sir talked about today, which talks about actionable claims other than lottery betting and gambling. The argument taken by the department was same, that this is all betting and gambling because money is involved. The Honorable High Court did not agree with that analysis. And in a roughly 350-page, very detailed judgment, and if people over here get the time, I would definitely ask people to read it, because I think it actually encapsulates the entire law relating to gaming and gambling in India very, very nicely. His lordship really, does a very, very thorough sort of job over there. And in the end, he formulates the questions and answers them. And very clearly, the answer to the question as to whether a game of skill played with money is gambling, the answer to that has been no. And therefore, on that first principle basis, the Karnataka High Court essentially held that since the answer to this is no, we will not get into the questions of whether there is even a supply of actionable claim or not by the platform or not. On that basis itself, we are squashing the entire demand and striking this down. So in a nutshell, that is what has gotten appealed. The department has in fact in front of the Supreme Court agreed that Rummy is a game of skill, and they're not challenging that aspect at all. They are simply saying that it is agnostic to anything. We'll see how the Honorable Supreme Court goes on to address this issue. From the industry's perspective, I think the industry is sticking to its earlier position that it took in front of the Karnataka High Court, which is essentially these are, as long as it's a game of skill, it does not fall within 31A. It definitely points out what Sir also pointed out to the fact that in one hand, the department says these are wagering contract. In the other hand, they're saying it's actionable claim. On first principle definitional basis, if it's a wagering contract, it cannot be an actionable claim, because you will not be able to enforce it in a court of law. So there itself, on pure definition of actionable claim, this falls, because the definition essentially comes from Transfer of Property Act, and if you look into that, you will see that it needs to be enforceable in a court of law, and a wagering contract is not enforceable, right? So that's pointed out. It's also pointed out that if there is an actionable claim at all, the platform doesn't supply it. If any, it is supplied qua the players, where again the doctrine of mutuality, etc., may come on to muddy the waters, so as to say. And then there are separate challenges that have now been made and questions pending before the Supreme Court on the constitutional validity of Rule 31A itself, as to whether the rule itself is constitutional or not. There are people who've challenged that. All of that has gotten now tagged in along with the same matter, effectively. So it's going to be an interesting, few months that I think we'll all live with. Hearing is supposed to commence from April. We'll see how that goes. And that's where it is today.
Wonderful. Thank you, Joy. Okay, now I'll set the floor open for people to ask questions. So either you raise your hands or you type your questions in the chat box, and do let us know who the question is addressed to.
I have a question here. When we're talking about legalizing sports betting in India for so many years now, and a lot of countries have benefited from this. If you see UK, it's a big industry generating a lot of employment, and of course, it has a lot of vices attached to it, but there are a lot of virtues in terms of employment it generates. So do you see that it will be accepted in India, and what kind of policy advocacy we should be doing for that?
See, I don't know. I'll probably take a stab at that. I mean, honestly, from our industry's perspective, we are not advocating any legalization of betting. I mean, sports betting, etc. Yes, there could be a case for legalizing, and you're correct. There are Ladbrokes and others who operate very profitably in places like UK, and they're regulated. So to my mind, if, and I'm sure people like Ladbrokes do intend to come into India, because if there are two things that sell in India, one is cricket, the other is Bollywood. And if you want people to put money into either of those, people will happily do that. So there is a business case that I have no doubt about it. In terms of how it can be done, I'm fairly clear that if the government were to even open it up, it'll need fairly, clear and strong regulation around it in terms of who can play, what is allowed, what is not allowed. But if you ask me, honestly speaking, I don't see an Indian government going ahead and openly saying we are opening doors for betting. It's just something that, to my mind at least, doesn't sit with our policy making. Optically, it probably is not even right from that perspective. So I don't see it becoming a reality in India anytime soon. From my industry's perspective, I don't care, honestly, because I don't need it. I don't want it. If somebody wants to come ahead and advocate for it, it's their call.
Adding to Khushbu's question, I remember the Tamil Nadu government's case in favor of banning, regulating online gaming is they made a sob story saying that so many families have been driven to suicide, poverty, all because there's one game. But they were not able to prove a single thing. It was not even statistics. It was simply arguments in the air. Would you have any comment on that, Jojo?
Yeah, so I think again, commenting on that, you're correct. I mean, there probably maybe anecdotal this thing on people, getting into loans. But what we have always seen from the industry perspective is that some of these have not even been properly looked at. And is it that the person took loan to play, or was it loan for something else, but he also played? So at the end of the day, if there was an unfortunate suicide, what was it regarding? I think that's, a question. And as you rightly say, the Madras High Court also notes that particular point and says that we have nothing in front of us to say that, there is a causal relationship at all. So I think from an industry perspective, we maintain that. Now, having said that, is the industry not mindful about any potential of misuse? I think that is not the case. I think as any responsible business, one needs to be mindful about the potential of abuse. And therefore, the industry, at least the bigger and the better players, would always welcome any kind of measure that fosters what we call responsible gaming. Now, to give an example, as Gameskraft, we have ourselves invested where we've gotten at the back end tied up with organizations which provide psychiatric counseling to people, and we make it available free, for players who we might identify through calls, etc., that come to us that may be vulnerable or are, saying things which may be problematic. We would try to read out them, see it's there. The idea is definitely not that, you do anything to a point that it becomes excessive. There are already gating mechanisms that the industry applies in the sense of giving soft nudges to people. For example, if somebody is playing nonstop, you give a nudge to say, do you want to take a break? Or, we notice that you've been playing for a long time and you're probably losing. Shouldn't you just, lay off? Now, a question may be raised that why don't you completely lock them out? Just force them out of the table. Now, the answer to that is it's not as simple. Let us say I do that. I force somebody out. That person will simply go and join the table in some other site. So you've not solved the problem in that particular manner. So the solutioning probably will have to come through, tech, which probably tries and gives them a break, interventions that happen. And maybe at some point of time with, development of AI, and if the government allows us access into those kind of financial data that a player has, being able to crunch and figure out who is vulnerable and who's not, before you let somebody onto the platform. And you have information sharing across platform. So if one is blocked here, the one gets blocked across every platform that is there. So that's probably where the future might look at in terms of responsible gaming. All I can say is that the industry is not averse to that. They're very okay to embrace that kind of a thing.
I see there's one question in the chat box. Which legislation is currently applicable to online games in India? Is it the Public Gambling Act?
So I think answer depends on what kind of games. If it's gambling, yes, it is the respective gambling acts of the states that is applicable. If it is skill gaming, then the law applicable as such is the intermediaries regulation, because the platforms are only intermediaries. There is nothing else that really regulates them today. As I said, we would love to have regulations which lay out maybe some other rules, which is absolutely okay. Apart from that, anything and everything that applies to an online platform applies to online gaming as well. So whether it is consumer protection laws or data protection laws, they apply equally to anybody.
Yeah. In fact, that was my next question to you, Joy. How do you take care of the data privacy laws? Because it's your website is probably a multi-jurisdictional game. So
today for us, we are only in India, but the moment you open the table up for people coming in from outside, of course you'll have to abide by GDPR, etc. That may be applicable. Today, we take consent. We lay it out very clearly in our privacy policy as to what data we are collecting and for what reason we are collecting it. We will be abiding by the DPDP and the rules that it comes out in relation to howsoever it's done. So to that extent, you won't find any of the proper players and operators in the industry, they follow all of these norms.
Okay, and also one more question. You spoke about the preponderance rule, something related to that. So what if there's a game where some of it has a chance factor and some of it has a skill factor? What happens? Like even for Rummy, if you ask me, I understand that the Supreme Court has held time and again that it's a game of skill. But when you're actually distributing the cards, it's actually a game of chance because you don't know what cards you're getting.
Yeah, so actually the Supreme Court has answered that question. The Supreme Court has actually said that there is nothing in life where there is no chance. There is no game where there is no chance. So therefore, the question was, preponderance. So you look at a game and you try and analyze what trumps. Is it chance that trumps? Like, for example, in the same judgment where they hold Rummy to be a game of skill, they essentially say Teen Patti is a game of chance. So when they talk about Rummy, they say Rummy, unlike the 3-card game, is a game of skill. So the 3-card game is purely a game of chance that is, taken essentially. Even in chess, which is probably the closest to a pure skill game that you can get, there is that factor that
white or black.
Exactly. So there is always that little bit that is there.
Or India, even the cricket pitches, whether it's spinner friendly or
you don't know.
Seam friendly or batsman friendly.
Yeah, if the air changes, something happens, rain comes, there is always chance. But how do you tackle it is your skill. So essentially, the test is preponderance at the end of the day. It'll become interesting, definitely, because today it's a subjective test. And I think in some ways you cannot always determine objectivity. Also, what determines skill can vary diametrically across games. So how you determine skill in chess may not be same as Rummy, may not be same as poker, right? So few things, if you look at studies that have been conducted, like for example, we've had IIT Delhi conduct a study in India on Rummy and poker, where they've used mathematical models to look into online Rummy and online poker and concluding that these are games of skill. So they have essentially done statistical analysis on set parameters and have said that when we looked into data sets, we saw that yes, skill is trumping chance. For example, few things that worldwide people look at are you becoming a better player with more gameplay? So is skill getting enhanced? Therefore, it's a skill game. Can you lose a game intentionally? Then it's probably a game of skill. Because it's a pure game of chance, you can't lose it all. Right? So there are those parameters. Mathematical models are today also being developed. And maybe in the future, you will have, when the regulatory bodies are properly set up, you'll probably have a subjective as well as an objective test that games will have to qualify in order to be labeled as kosher in India. So you will probably get a legal view. Lawyers like Sir or us will, provide an opinion on, or you, and that channel will be open where you look at it from a legal perspective and say, okay, looks like legally this is preponderantly a game of skill, but at the same time you'll have, it being run through probably a simulation to essentially see from a statistical point of view how is it looking, and those tests could differ from game to game, but chances are that in future you will get those tests because already work is being done on a lot of these aspects.
Okay. Any other questions from anyone?
Yeah, hi, Arindam Sarkar.
Hi,
I just
hi.
had two short questions. What are the top 2 or 3 technical advancements that you are seeing in the gaming industry that are going to happen in future that I would like to know? And second question is, when is Delta Corp share getting back to normal?
The second question I cannot answer. That probably will be a game of chance as well, as to when it is going to get. But the answer probably is as and when I think all legal debates get settled, you'll probably see something. Markets will reflect that. In terms of technical advancements, I think the areas which are getting strengthened every day are in relation to KYC, because, it's very essential for gaming operators to understand who has come in to play the game. So linking from registration to money in to money out, that it's the same person and the person is allowed to play, holds valid credit cards, it's his credit card, it's not stolen, because there have been instances where, the Jamtara gang has stolen somebody's card, played on a online platform and has gotten out. So those kind of things have happened. So there is a lot of technical advancement that is taking place on prohibiting and, making sure that that doesn't happen. So KYC checks have become sophisticated. Fraud analysis is an area where there's been a lot of technical advancements, and it'll keep on happening, because what you don't want is the platform to be gamed for doing anything else. Fraudsters are everywhere in the online world, and there are innovative mechanisms. So it's always a cat and mouse game between, our tech teams and the fraudsters trying to figure out, how it does. But a lot of AI, ML, related work is being done on fraud. So you will see a lot of enhancements that'll be there. And third one is going to be very, very, I think, consumer centric. India still doesn't have what we call, proper AAA games. That's all PUBG and everything comes from outside of India, right? India has done the smaller card games well, where it's not that heavy on graphics, but slowly but surely, there is going to be a rise of gaming studios in India. Lot of tech. India has the tech talent. I think now you will see India coming into those high on graphics, multiplayer, multi-jurisdictional kind of games. I would say in the next 5 years, you will at least have, stuff coming out of India on that as well.
Okay. Any other questions? Otherwise. All right. Thank you, Mr. Viraraghavan, and thank you, Joy.
I have a question.
Oh, yeah, sure.
Sir, when in online games, if there is microtransactions involved, so there are many games where microtransactions are involved, other than this Rummy and such kind of games. So it will be, we can play it directly, but there can be microtransactions, like they can buy properties for games. So in such transactions, if consumer is affected by anything, where they can complain about this microtransactions? Is there any law regarding that, or is our Consumer Protection Act is covered under for this microtransactions?
Sure. So, I'll let, sir also comment on it, but I'm assuming you're talking about in-app purchases kind of scenario.
Yes.
Games. So in an IAP kind of a game, there are those microtransactions. I would say, yes, you are protected under your consumer, laws. Obviously, if there is something nefarious going on over there, you do have a case as far as the lawyer is concerned, apart from your normal first degree complaint always to the company in figuring out that, for example, you're playing a game where you wanted to buy some extra power and you paid the money, you didn't get it. So of course you'll make that complaint, and as long as you can prove it, there should be a case. I don't know, sir, if anything else that you feel.
I agree with that, because the underlying basis of consumer is deficiency in service. So if there is a platform where service is deficient, somebody rips you off, yes, you have charged.
Sir, is there any jurisdiction for that? Like where, because since it is an online game, the consumer might not be knowing from which area this particular industry is. So they can, whether they can file in any consumer court, or is jurisdiction is mandatory?
A couple of things occur. Now, where your computer and you sit, that's the best place for jurisdiction.
Exactly.
You can say you were ripped off there. You probably try that's the best, I think, from your perspective, but registered office of a gaming company, or where it has its back office, that can also be another.
Absolutely. I think you'll simply go by CPC over there and figure that out.
Thank you, sir.
Okay. Thank you, sir. Thank you, Joy, for taking time out of your busy schedules. And it's been really enlightening for all of us. Thank you very much for this wonderful session.
Thank you very much.
Thank you.
It's been a pleasure.
A pleasure.
Thank you.
Bye.
Have a good weekend, everyone.
Thank you.
Bye-bye. Thank you.